Miss Aswood, I'm just checking to see that you can hear me well because
Yeah, I can hear you well.
okay, all right, thank you.
You're welcome. I'm pretty sure Ms. Greening should be joining us shortly.
Okay.
You see that she's accepted the link, so.
When are you here until? Okay, until the end of May.
Good afternoon, Ms. Greening. Just making sure we can hear each other. But you can hear, I can hear you.
Good afternoon. Can you hear me?
Yes, I can hear you.
I was just keeping it on mute because there's some noise in my office until I have to speak.
That's fine. Thank you. Gina, you can read up the heading. Wednesday, the 20th day of April, 2022, Court Commercial Court 2 via Zoom at 2:40 p.m. before the Honorable Justice Sibir Williams, Appellate Jurisdiction 2021, number 32. Lamont Marshall versus the Queen. Victoria Green for the appellant. Maria Zephianos for the respondent.
Thank you. Yes, good afternoon, Council.
Good afternoon, milady.
Afternoon, my lady.
Sophianos?
Good afternoon, my lady.
Yes, good afternoon.
Sorry, my mute was on.
It's fine. Well, let's get started.
Yes, good afternoon. This is the second half of the appeal against the Crown by my client, Lamont Marshall. In the first half, I'll call it last week, Her Ladyship asked the Crown to provide supplementary submissions. I may have misunderstood, and it's not really for me to say, but I had thought that the reason for your supplementary submissions, or the request for supplementary submissions, was to respond to my portion of the submissions that analysed the road traffic of the Traffic Offences Penalties Act.
I was not intending to be so restrictive because your submissions were very belatedly received by Ms. Sophianos. And
Okay.
so I think it's only fair that if she wanted to go beyond any particular scope that you might have thought she would narrow her focus to, that she could.
Yeah, well, in any event, she maybe quite rightly focused on what seemed to be the issue that was in most focus, in being looked at most closely at the last hearing, which was whether or not the case of Goodyear applied to the ground that we have laid out in our notice of appeal, raising the issue of whether or not the magistrate in DUI court misled the appellant when he gave an indication as to how he would be sentenced. I've read my learned friend's submissions. I don't agree with them. And I have now taken the time to think carefully about how this scenario has unfolded in the fairly unusual situation in that we have this DUI court in the middle of a sequence of events leading to a sentence. So at the time of my client, the appellant pleading guilty in the substantive court, he was told that he would be allowed to enroll in DUI court. Now, of course, we know that DUI court is a fairly recent court that has a unique jurisdiction. And the result of that is that it could have resulted in the appellant having his conviction quashed altogether. And this is the carrot dangling on the stick to encourage a defendant going into DUI court to stop drinking, to put it bluntly. Goodyear says, and although we are all in agreement that Goodyear specifically deals with someone who is given an indication prior to pleading guilty, Goodyear says generally that there is to be no bargaining with or by the judge. And that is at the top of page 287. On this basis alone, it could be argued, and this is not a ground, you'll see that this ground was abandoned. On this basis alone, it might be argued that DUI court is inconsistent with Goodyear or even unconstitutional, as it is in breach of a defendant's right to a fair trial. On the basis that he's in the substantive court, he or she is in the substantive court, given this incentive to plead guilty so that he can be enrolled in a court that will give him access to services. And if he's compliant and successful with whatever sanction or conditions in the DUI court, he could have a graduation and have his conviction quashed, which would result in no sentence whatsoever, obviously no conviction, no sentence whatsoever. In any event, when my client, the appellant, got into DUI court, it would have been made clear to him that if he had complied, as in ceased from drinking and other conditions, then he could have had his conviction quashed, or if not, his enrollment could be terminated and he'd be sent back to be sentenced in the substantive court. On the 31st of August, the appellant was asked to make a choice. And this is where it becomes a little bit unusual, which essentially would result in keeping the possibility open of having his conviction quashed if he decided, yes, I want to stick with this court, I want to try and work with everyone, or he could be sentenced. So at this stage, he and the judge are entering into, unwittingly or otherwise, a sort of bargaining or negotiation. The judge was not asked by the appellant or by counsel what sentence would be imposed before he made the decision. And of course, that would not have been appropriate, as that would have fallen into the category of Goodyear, in that the appellant had to make his decision voluntarily and not under any improper pressure, as Goodyear couches it. Because, as I've already stated, there can be no bargaining with or by the judge. The situation where the judge in DUI court has offered to my client an indication without any request, in my respectful submission, and this is the crucial part, is absolutely no different. To test this, milady, we can pose the question: do you think it would have influenced the appellant differently if the judge had said to him at that time, it's up to you, the choice is yours, you can stay here and be compliant or go back to be sentenced and I'm going to give you 6 months imprisonment? And of course, the answer is yes. The defendant immediately lost his job as a result of being imprisoned, and his wife was in the late stages of pregnancy, and she would have given birth had he not been successful at his application to be bailed pending this appeal. So he would never have, I mean, for those obvious reasons and others, he would never have agreed. I think in an already constitutionally dubious situation, that being DUI court, and where the appellant had to make a decision about whether to be at the mercy of sanctions and conditions imposed by that court, or to go to be sentenced, where he was given a clear indication twice by the magistrate that that sentence would involve disqualification and a fine. And then to go to the substantive court and be sentenced by the very same judge or magistrate, with a term of imprisonment is equally unfair, because we're saying now that it was unfair in the first place. The Crown keeps referring to the conversation, and I note that in the submissions, my learned friend uses the word conversation numerous times between the magistrate and the appellant, as if it was a conversation between equals, which of course it cannot be. The very nature of a magistrate and a defendant with his future in the magistrate's hands means that there cannot be any conversation. The power imbalance means that cases like Goodyear need to give strict guidance to the courts, to the prosecutors, and to all officers of the court in how to deal with these matters, so that defendants do not find themselves in the position that the appellant is in today. And for all of those reasons, well, those are my responses to my learned friend's supplementary submissions, milady.
Thank you, Ms. Greening. Well, Ms. Sofianis, without wanting to invite too much of a back and forth, is there anything that you wanted to elaborate on the submissions that were received today?
Well, my lady, yes, and I don't want to rehash everything we talked about last week, but the court would be aware that the drug treatment court program, and I say the drug treatment court program, which is found in our criminal code, came about in 2001 as an alternative to incarceration program. The DUI program is modeled after that same type of premise, in that there is either a finding of guilt or a plea of guilty, and the defendant is then in that program for a period of time where they have to do certain things, and it's usually aimed towards helping people with their addiction, whether it be drug or alcohol. And in this case, I would say that all of these programs and all of the helping courts are meant to help rehabilitate people and offer them an alternative to incarceration. Going back and considering Goodyear, again, the guilty pleas were entered in April of 2021. So I would ask this court to consider there was no inducement, no undue pressure or influence given by the judge. And again, if those those portions of the conversations are looked at, and I put them in my supplemental submissions at paragraph 3, you'll be off the road probably, my emphasis was added, for 5 years. This is your third offense. What do you want? And again, that's the problem there. And you would rather, my emphasis added, be off the road for 5 years with a $5,000 fine. When you compare that to what happened in Goodyear, which again was prior to plea, the conversation was much different, and that's found at page 286 of that case. It says, the judge told counsel for the appellant, yes, in those circumstances, I can revise what I said earlier. I do take the view, by contradistinction to the case of Mr. Stones, who was a public servant and may be in a rather different position, but I do take the view that this is not a custody case. I mean, that was an explicit undertaking. They discussed custody in that situation. It was a Goodyear type of situation. That's what the case is named for. And that was a before plea discussion that took place. So I think this situation is much different. And that's why I continually refer to what took place as a conversation between the judge and this defendant. I do want to go back one more time and take the court to the section that my learned friend referred to earlier, which is section 2.3 of TOPA, which is found at tab 3 of my original authorities bundle, my lady.
Yes.
And section 2.3 starts off.
One moment. Sorry, where in TOPA am I looking?
Paragraph 2.3 of TOPA.
Thank you. Yes.
It starts off, where in head 5 of schedule 1, different penalties are specified for second, third, or subsequent offenses against the same section committed within 2 years of the date of conviction, etc. And this is why I'm saying section 35AA is different. If you look at, for instance, I think I took you last time to the speed.
You did. You definitely took me through
Okay.
this. Yes.
And driving whilst disqualified is the same, except I did make a mistake on the last occasion. Let's look at page 32 of the Traffic Offenses Penalties Act and look at disqualified driving, for instance. And considering he does have a previous offense for driving whilst disqualified on the 20th of August, 2009. If you look at head 5, it says, if the first offense, $1,000 or 3 months, which I had submitted was the correct application in this case. It says, if second offense committed within 2 years of the date of conviction of the first offense, $1,000 or 6 months. So that's specific, but it says if second offense in any other case, $1,000 or 3 months. So I would say in this case, it is actually a second offense, but it's in any other case because his first offense for driving whilst disqualified was in 2009. It boils down to the same penalty, but it is specifically laid out different to that in section 35AA and how that is laid out. So I would say that my learner.
You accepted, sorry, I just want to make sure I'm following you. You accepted that the 6 months was ultra virus
Yes,
and that the 3 months is what
Yes.
would have been, okay, thank you.
Yes, but I just had to correct that I had worked it out the wrong way. And I would suggest and submit to this court, the paragraph 2.3 does not apply for the 35 AA because we need read no further because there is no specific portion laid out for 35 AA as in those other two offenses we just talked about. Because
Right.
again, if you go to page 17 of the TOPA, you will see there's no specific offense laid out as it is in those two other offenses, driving whilst disqualified and speeding that we referenced earlier.
Right,
So I would submit that we should read no further. And in considering the offenses of this appellant, who previous offenses were on the 4th of June, 2009, excess 80, the 14th of August, 2015, impaired, the 12th of June, 2020, refusal, I would submit this would be his fourth offense. So we must read it as we did, and I would say that the learned senior magistrate did correctly if it's the third or subsequent offense. So for that reason, I would say and submit to this court, my lady, that the learned senior magistrate did not err in his sentence.
right. Reserve judgment,
I'm obliged, my lady.
and I will communicate to the parties through the registrar as to when the matter is to be relisted for judgment to be.
I'm obliged.
Okay,
Thank you.
thank you.